Hannah Whaley, and it just started. Thank you everyone for attending today's webinar. My name is Attorney Hannah Whaley. I am the Senior Business Immigration Attorney here at Eagan Immigration, and today we're going to talk all about the self-petitioning options that are available, and I hope today's conversation brings you hope and some excitement for the future. We will wait just a few more minutes to see if anyone will trickle in, and then we'll get started. Thank you so much for everyone who is on the stream right now. We are having a few issues with streaming on some of our other services, so we're just going to wait a few more minutes to make sure that everything is up and running so that everyone who wants to attend and view today's webinar is able to get on here. So we're just going to wait a few more minutes. Welcome, everyone. We're just waiting about one more minute just to make sure that all of our connections are up everywhere else that we're streaming, such as LinkedIn, YouTube. And just to let you guys know ahead of time, there will be a question and answer session. So feel free throughout the entire presentation to drop questions within the chat box, and we will get to them at the end. Or feel free to send me an email if you have a more specific question to hannah.whaley@eganimmigration.com. And don't worry if you didn't catch any of that, it will be reiterated at the end. But again, you can drop comments in the chat box throughout this presentation, as well as emailing me personally. And we're just going to wait one more minute. All right, it's time to start today's webinar. For those who have just hopped on, my name is Attorney Hannah Whaley. I am the Senior Business Immigration Attorney here at Eagan Immigration, and today we're going to discuss self-petitioning options for work visas in categories here in the United States. And I'm super excited to present this to you guys and allow you guys to either, again, have some hope for the future or some excitement about the possibilities that lie before you. And while we go through this presentation, please feel free to drop any questions that you have in the chat box, or feel free to email me at hannah.whaley@eganimmigration.com. And the email will be at the end because I did see someone ask me to drop it in the chat. I will do that for sure, but it's also located at the end of this presentation. So to give a brief overview of everything that we will be discussing today, we will be going over an introduction of what a self-petitioning category and visa looks like, the definition, the benefits of being in these categories, the qualifications that are required to fulfill these categories, what the categories are themselves, as well as the big question that everyone has is processing time. How long will it take? So the first question is, what is a self-petition? A self-petition essentially is it means that an applicant is able to file for an immigration benefit without the need of an employer or any job offer. And this is just such an attractive category to so many people because most individuals believe that in order to get a work visa, you must be tied to an employer, you must be tied to a job offer, and that is the only way to go about it. But you can do this by yourself. And a self-petition just means that the applicant is being evaluated on their own merits, as opposed to when you're sponsored, you're being evaluated either based on your employer or your employer, as well as your merit and your education and other different factors. Why self-petitioning might be best for you. So the big three things that we have for self-petitioning is the independence, the flexibility, and faster processing times. First, let's start with independence. As I previously said, when you self-petition, you do not need an employer or a job offer. What exactly does that mean? That means that while you are in this status on a green card, you do not have to worry about renewals with your employer. You don't have to worry about whether or not they're going to sponsor you moving forward. You have the safety and security of knowing that you can change jobs and do as you want without the need or the tie to an employer. Next, we have flexibility. Part of one of the most beneficial aspects of self-petitioning and not being tied to a job offer means that you're able to switch jobs without the need of reporting to USCIS or having to change forms or any of that. That is not required when you self-petition. Instead, you'll just have that green card and you can change as you please. And that is one of the best aspects of it and grants a lot of applicants a lot of stress going into this process. And last, we have faster processing. This is, if not one of the largest benefits of being in a self-petitioning category or business visas in general. And we'll discuss this a little longer down in the presentation, but for family-based petitions, you're looking at maybe 2 years just to get your application looked at, while in these self-petitioning categories, you could get an answer in less than a year or even in a few months. And that is a huge difference in time. So that's why self-petitioning may be best for you if these three things are very valuable to you as far as what you look for the future of your immigration history and what your goals are. Benefits. So one of the major benefits is that these categories that we're going to discuss today are actually employment-based green cards. And what this means is that if you apply for this category and you do receive an approval, you will become a lawful permanent resident, which means, again, no renewals. You don't have to worry about having to leave. You can live and work in the United States indefinitely. Next, we have work freedom. As I stated before, you're not tied to a specific employer or a job offer. Therefore, an individual has the flexibility to grow their career in the way that they want because you don't have that tie or that the administrative aspect that a lot of other visa categories, even in the business side, require you to do with USCIS if you are to change jobs or employers. So that work freedom is amazing. And not lastly, another aspect is no renewals. Like I said, if you're familiar with a lot of the other work visas, such as the H-1B, the O's, the L's, all of those require regular renewals. And even if it is a temporary visa that you can get renewals for indefinitely, you're expending more financially to maintain a status, as opposed to with these categories, you're able to get that green card and you don't have to worry about renewals. So the employer's saving money, you're saving money, and you have the comfort of knowing that you're here permanently. Other two benefits is citizenship eligibility. As a green card holder, you do become eligible after meeting certain requirements to apply for citizenship, which I know is a big goal for a lot of people, for themselves, for their spouses, for their children, which is why these categories for self-petitioning, they're just so vital and so important. Next, we have social benefits. One of the largest aspects of being a green card holder means that you are now eligible for social benefits. That includes education, healthcare, Social Security. It's so many benefits that can help you as well as your family here in the United States. And these are just some of the many reasons as to why self-petitioning, especially for an employment-based green card in these categories we'll discuss today, is such a benefit. So the types of employment-based self-petition. First, we have the EB-1A, extraordinary ability, and the EB-2 National Interest Waiver. These two categories require different things and different requirements, which is why they're separated in this manner. So first, we will discuss the EB-1A. So the EB-1A is specifically for individuals of extraordinary ability. What USCIS is really looking for here is an individual who is rising above others within their field. And this doesn't have to be in a drastic and extraordinary way, but USCIS wants to see this individual is performing on an extraordinary level. And specifically, they would like to see it in the areas of science, arts, education, business, or athletics. And I would like to say that if you're thinking, I might not be in one of these categories, it is likely that you would fall in under business in some way, or you could be adjacent to one of these categories. So I would not rule yourself out so quickly for the EB-1A. So how do you qualify? So there are two main ways to qualify. First, we're going to go over the first one, and that's if an applicant is able to demonstrate that they've received or sustained national or international acclaim or recognition. Now, if you meet that, you do not have to show other elements. However, if you're unable to show this, you must show 3 of 10 other requirements, and you can choose the 3 as you see fit or how you fit into the elements. But first, you can fit into this category by having a national or international recognition or award of some form. The other way, again, is meeting 3 of the 10 requirements. First, we have receiving lesser nationally or internationally recognized prizes or awards for excellence, membership in associations in the field, published material that covers you in some form of publication or media, evidence that you judge the work of others, commercial success in the performing arts, original contributions, authorship, having your work displayed at exhibitions or showcases, specifically artistic for exhibitions, evidence of being in a leading critical or distinguished organizations, or evidence of commanding a higher salary or just higher financial gain or specifics in relation to your skill or the product that you produce. And before we move on, I do want to talk about a few of the elements that are displayed here. And I want to talk about the ones that are usually the biggest concern or confusion among clients and potential clients that I speak to. First, we're going to start with judging the work of others. A lot of people look at this category and this element and they decide they may not fit because they're concerned with the level of work that they may have judged and whether or not that actually rises to the occasion of meeting this element. However, what USCIS wants to see in this category isn't about the level at which you are judging the work of others. Instead, USCIS wants to see that you judge the work of others and you utilize that specific skill in order to do so. One great example that I love to use for this category is someone who is a pageant queen or a model. A lot of times we see pageant queens who judge smaller level competitions for, the cute little children or middle school age kids up through high school. Any of those levels would work and fulfill this criteria because in this situation, the model or pageant queen is utilizing her skill within the pageant field to now judge the work of others who are below her or younger than her and utilizing that skill. That is exactly what USCIS wants to see with this category. Now we're going to jump down to critical or leading role in distinguished organizations. This is one that confuses a lot of individuals, but a way that you can also fulfill this specific requirement is if you played a part in your company receiving some sort of recognition. I've seen this popularly happen when it comes to STEM fields or some of the more culinary fields, such as the chefs, where the actual restaurant receives like a Michelin star, or you have a STEM organization that is recognized for a project in which the applicant actually worked on. You can meet this element by showing, yes, the company received this award, and providing maybe letters or anything of that nature that speaks to the specific part that you played in helping the organization receive this recognition. That is a great way to show within that category. And lastly, commanding that higher salary or higher financial gain. In this situation, what USCIS really wants to see is that, for example, let's use electrician. If generally an electrician makes around 75 or 80, but you are making 130 because you have all of these certifications and you're able to offer, let's say, an additional service because you took this schooling or did this training, you can show that now you are also extraordinary because you're not being paid what everyone else is because of that level of skill, because of that added benefit that comes with working with you, because you are extraordinary. That is what USCIS wants to see in this category. Another way you can show this is if you're someone who creates a physical product and that you have a group of people or you have individuals who are paying you for this, having copies of those receipts or those purchase orders and showing that individuals are investing finances into your craft is another way to meet that element. But again, for this, you only have to meet 3. If you meet more than 3, that is amazing. Throw everything at the wall to qualify. But the best part is that you only have to meet 3. Family members. This is obviously one of the biggest questions because, of course, we all, seeking immigration benefits, we want to know, what about our children? What about our spouses? And the perfect part about these categories is that if your petition is approved, your spouse and any unmarried children under the age of 21 also receives the exact same benefit. Yes, that means they get the green card. That means they're legal, lawful, permanent residents. And that provides so much relief to applicants knowing that they don't have to do this alone. They can bring their family either at the time of approval and entering, or if you're here with adjusting and they're not here, your family members, they could also petition to follow. There are ways to do it, but just know that your family members, spouse, and children who are unmarried under the age of 21 are able to obtain the exact same benefit as you as derivatives on your application. Now we're going to talk about the second one. This is the EB-2. This is the National Interest Waiver. And what makes this different from the EB-1 is the EB-1 is focused on that extraordinary ability, while national interest focuses on education and the need here in the United States. And there are 3 ways to qualify for this employment-based green card. First is if you possess a bachelor's plus 5 years of qualifying work experience, and we'll talk about what qualifying means, possessing an advanced degree, which equates to a master's degree or higher, or if you meet the requirements of exceptional ability, which we will discuss later on. But first, we're going to break these down a little bit. When we talk about this bachelor's degree plus 5 years of qualifying work, we have to understand what qualifying work entails. And in the eyes of USCIS, qualifying work is only work that was obtained after possessing the bachelor's degree. So unfortunately, if you did work in your industry before obtaining your bachelor's degree, you cannot use that as qualifying work experience. As well, for qualifying work experience, it's important to understand that qualifying means that the work must be related in some way, shape, or form to the degree and the career that you are petitioning under. So for example, if we'll just use me, if I'm an attorney filing for an EB-2 NIW, but all my work experience is in retail and makeup, it doesn't count as qualifying experience. USCIS is allowing essentially the equivalent to a master's to be that bachelor's plus 5 years of work experience. So what they're looking for is, can this individual actually do this job? And that's why the 5 years of qualifying work experience is very critical. Now let's talk about the requirements for exceptional ability. For exceptional ability, like with that EB-1A, you only have to meet 3 of the following. And I love the exceptional ability because it's a step below extraordinary, but it still gets you to the same point. And this is a category that I see a lot of entrepreneurs usually qualify in. And that's because the requirements are a little more broad. First, we have an official academic record that shows a degree, diploma, certificate, or a similar award. Here, this just means anything relating to an institution. And I love this one because if you do not have a traditional 4-year or an advanced degree, you can qualify. Let's say you're an entrepreneur who works in tech and you have tech certifications. You're able to qualify under this element with those certifications. Next, we have letters from current or former employers documenting at least 10 years of full-time experience in your occupation. For entrepreneurs, if you haven't worked with an employer, what USCIS wants to see is that you can at least provide proof of operating in business for those 10 years. But what USCIS is really doing within this element is that they want to see that you truly did work and they work in this industry, and they want proof of someone vouching for your presence and your work ethic over the course of 10 years. Next, we have a license to practice your profession or certification, evidence of commanding that higher salary yet again, that's demonstrating your exceptional ability or any, again, financial services, membership in professional associations, recognition of achievements and significant contributions to your industry or field. And I love this one because this can be by peers, government entities, business organizations. So the pool is pretty wide under this element as to getting vouched for as to your achievements and contributions, which makes this an easier category for a lot of people to meet the 3 of the 10. And next, we have other comparable evidence of eligibility is also acceptable. A lot of people get confused about this one because they don't understand what comparable evidence is. Comparable evidence just means it may not fit fully or perfectly into any of the above. However, it still demonstrates that you're exceptional in some way, shape, or form. So don't think there's no way you can qualify. If you're like, I only think I meet 2, there may be a way. And there's a lot of things that people just don't look at in their careers thus far that do qualify as comparable evidence of eligibility. So that is that nice little catch-all one that helps support the others. Now with the EB2, unlike the EB1 where you just meet the requirements, if you either have that national or international acclaim and then or either 3 of the 10, for the EB2, you must first meet those requirements of either having that bachelor's plus 5 years, advanced degree, or exceptional ability. And once you qualify into one of those categories, you must now meet all 3 of the following elements, which is national importance and substantial merit. That's 1 in how USCIS evaluates, well-positioned, and on balance. Substantial merit. So substantial merit and national importance definitely go hand in hand, but the difference is that substantial merit is the part that focuses very narrowly and specifically on the applicant's work in their field of endeavor. This means that they want to see what does this individual want to do in their career? Are they able to do it? And does it have merit? And merit just means that it will have some sort of impact or is connected to something that has a very specific outcome. And you don't have to show immediate or quantifiable economic impact. And what that means is that USCIS is not looking for you to say, I can generate 5 jobs, or I can come to the United States or adjust status and I'll be able to train 10 people to fill this role. That's not what they're looking at. They want to see that the applicant has a very specific endeavor that is connected to their ability and skill, and that it is of merit and it is important to the nation's goal. Now, with national importance, they look at it on a broader scale. And what USCIS is looking at now is, how does this individual skill affect us on the United States on a larger scale? Does it advance technology? Does it help our healthcare field? That is, let's say if we're having a shortage in healthcare, does it help alleviate this issue, whether by you being able to enter the field or train, education, other areas? But what they want to see is, what is the national impact of your substantial merit? So what we want to see within substantial merit and national importance is that hand-to-hand connection of, this is my skill, this is what I do, this is the effect, and now this is how it will affect the United States, on a national scale. So the importance here again is on that broader societal impact of your work. And if USCIS does not see the national importance, they will question whether or not there are any national implications. And the reason that this is so important is because this specific category hinges on the fact of bypassing the labor certification process. So if there isn't national importance, USCIS will not grant this waiver to the applicant. Well positioned. This is a requirement where USCIS looks at, does this individual actually have the skill to further their work and their impact as they do at home or in their career when they adjust or come to the United States? And the way I like to frame this to clients is, will you be able to come here and start immediately? And a lot of people get a little stressed, especially those who are in the medical field, when you have to come to the United States to take certain exams or go through certain requirements. You can show USCIS that, yes, but for entering the United States, I am prepared to enter the field. What that means is that if there's a test that you must take in person, once you enter the United States, USCIS will still say that you're well positioned so long as you've done everything to that point. However, if you have all this skill, but you also need to do 2 years of training, you have to go through this 6-month X, Y, and Z, USCIS will likely find that you are not well positioned to come into the United States to continue that valuable work. So what they want to see is, do you have the skill directly related to what you want to do? And do you have the actual ability, achievements, and qualification to do so almost immediately? Last, we have on balance. To me, this is really not an element. It's really about everything else that has been provided thus far up to this point. And what USCIS looks at for on balance is, does the weight of everything that this applicant provided outweigh the need to go through the labor certification process? And for those who are unfamiliar with the labor certification process, this is a process where an employer sponsors you, and you must go through the Department of Labor and get the employer must be approved there. And then you have to apply with USCIS after you've received that approval. Now, with this EB-2 NIW, the National Interest Waiver allows you to cut out the Department of Labor, employer, and job offer part, because the career field that you're in is of such national importance, or your skill is of such national importance, as to essentially allow you to skip the beginning part of that process and only being evaluated as an individual. So the important part here is the evidence that you provided, is it credible? Is there a large volume? Do you have enough letters to vouch for the work that you've done? Do you have proof of your degrees? USCIS wants to see that the weight of all the evidence you provided says, yes, this applicant does not need to go through the labor certification process. So when it comes to doing an EB-2 NIW, you want volume, but you want quality volume when it comes to evidence. Provide the best letters that you can. If you can get some from experts, put them in there as well, because you want the balance scale to lean in your favor as opposed to equal or below. Because if it is equal or below, USCIS will not give you that waiver, and they will tell you that you need to go through the labor certification process. And because we don't want that happening, you want to make sure you provide the best evidence in as much as possible. That's why I said in previous categories, with the EB-2 NIW, let's say you're doing exceptional ability. If you meet 3 of the 10, but you can show 5 of the 10, always show more, because that balance, that scale is just going to keep tipping in your favor. And that's exactly what you want when it comes to the EB-2 NIW. So processing times. So before we get into the processing times right now with the EB-1, I do want to compare this to family-based petitions. Yesterday, when I looked online for family-based petitions, and this is processing time, just means the part with USCIS. Keep in mind, depending on where you're at, you might have to go through National Visa Center, interviews. There are other things that occur after just receiving an approval. For immediate relatives, as of yesterday, it showed 51.5 months at one center and 56.5 months as far as processing for all of their service centers. And I'm going to say that again, 51.5 months to 56.5. Now with the EB-1, and these are the only centers where they're processed, Nebraska's taking 17 months, Texas Service Center is taking 20 months. And even better, my favorite category, the EB-2 is taking 6.5 and Texas is taking 8.5. These numbers compared to 51.5 and 56.5 are marginally and extremely lower. And being able to at least get through the beginning approval and processing in this much time is amazing. And I do want to say, I don't want you guys to be stuck to these numbers, because if you're not familiar with how processing times work, they can change at any time, which is why you have to try to, if you know you're seriously looking into these categories, you want to take advantage of these lower processing times while they exist, because they can change at any period of time. Especially those looking into the EB-2, 6.5 to 8.5 months is absolutely amazing. It makes me smile because it just excites me. But that is the end of today's webinar. I hope you guys received some sort of value and excitement about the opportunities that lie before you as far as employment-based green cards. And if you're one of these individuals who watched and you're like, I think I might qualify and I really want to try, set up a consultation with me where you can use the code Eagan webinar to waive the $200 consultation fee. And even if you're not fully sure, you have doubts, there's nothing wrong with seeing if you qualify or what you may need to do in the years to come in order to qualify. And if you're not ready to take that leap of faith into a consultation and see what your odds are, you are more than welcome to contact me personally at my email at hannah.whaley@eganimmigration.com. If you send me your questions, I will try to advise you as best as I can and let you know what opportunities lie before you. But before we end today's webinar, I'm going to go and see if we have any questions. I'm a VFX artist. I'm not sure. A virtual, I assume that's somewhat STEM or computer or graphics connected. As far as it goes, the EB-2, because you have that national interest aspect of it, national importance, because you're saying what visa should you get without sponsorship, depending on what the growth projection is for your field or what it is for your job title, you could possibly qualify for an EB-2. But what would need to be done is, as an attorney, I always do research on whatever category the applicant wants to go into prior to signing and get an understanding of what their skill is so that I can recommend the best visa category. And that also depends on your education and anything else as well. So if you want a more personalized answer, you can shoot me an email or sign up for a consultation where we can do a more in-depth evaluation. And it seems as though that is all of the questions for today. And someone said, can we get a recording of the webinar after it ends? After the webinar, I want to say within a few days, we always put a copy on YouTube. card. Oh, okay. There are more questions coming in. Perfect. How much money will be required from application to landing the actual job? So again, I want to remind you that you are not obtaining a job. You are getting a green card. So you're not tied to a job. If you're talking about starting the case to the end, what fees you can expect to pay your your petition fee, your I-140, which is $715. If you're inside the United States, you have to pay for an adjustment, which I think just went up to 14,000, well, not 14,000, sorry, 1,400 something. It's around 1,400 for that adjustment. If you're outside the United States, you have to pay your immigrant fee, which is $235, as well as fees with MBC to get signed up and go ahead with your interview. So if you want the specifics, I can list them out for you, but that really depends on whether or not you will be consular processing, i.e. coming from outside the United States, or you're adjusting. Those charges are very different. What are your, our charges are, you can, if you email me, I can send you a full sheet. We actually have a sheet as well as some payment plans, but they're flat fees and they're really good. So I would suggest shooting me an email and I'll be sure to send you those rates. How does USCIS handle foreign-based degrees? Oh, I love this question. So with foreign degrees, what USCIS does, especially because I assume you're talking about the EB-2, with the EB-2, your foreign degree, you can use a foreign degree as long as it is the equivalent, and it must be the equivalent in itself. And what I always push my clients to do, well, actually require, you need to get a degree evaluation and make sure that your degree is either the equivalent of a bachelor's, if you're going through that bachelor's plus 5 years, or make sure that your foreign degree is an equivalent to a master's. And unfortunately, you cannot combine your degrees if you have multiples in order to fulfill either of those categories. But if you would like to get an understanding of what your degree might be equivalent to, I would suggest reaching out to Park Evaluations. It is a well-known evaluation and translation service, and it's what I recommend to all of my clients. And if you go on there for $80, I think, to get a degree evaluation in 3 days, you will know exactly what your degree is the equivalent to. And to get that degree evaluation, you're also not only going to want your degree, you need to provide your transcripts as well. And I suggest doing that if you know you have a foreign degree and you are looking to join or go through the EB2 NIW. And if that did not answer your question, again, please feel free to shoot me an email. Next, I'm working in banking industry since the last 13.5 years. Can I apply to any of these categories? Yes, specifically if you have, again, that bachelor's plus 5 years or that master's degree. And I know the banking industry is one that has a lot of growth, just because I've had to do some research on that lately, depending on what exactly your job title is or your career thus far. You could definitely get an EB-2. I would not suggest an EB-1 for someone who is well into their industry, especially if you're in the industry that is growing to a certain extent. An EB-1, I feel like, is a great opportunity for those who have a lot of accolades and awards that probably won't fit within the EB-2 criteria. But you could likely apply for an EB-2. It would just depend on what exactly is your job title, me doing that research into the industry and what the need is here in the United States. And once I know that, then I can tell you what a full picture looks like as far as should you apply, is the growth where it's at, and what are your chances of success. Does the approval of the and I assume you mean 140, mean that the application will be approved? Yes. So what that means is for business visas, or let's just go with the EB-2 and the employment-based green cards, but you apply for that I-140, which is the petition for in terms alien worker. Once that's approved and you're outside the United States, it just goes to the National Visa Center, where you're given a visa number, you're having to do everything online, and then go through your interview. What matters for these two categories is that you get that approval, as well that you don't have any other issues in your immigration history. So if you have any unlawful presence or unauthorized work, I would say reach out if you're looking into these categories, so I can make sure that it won't cause you any implications later on or throughout your process. If anyone has warrant issued by the U.S. government, a warrant issued, I would want a little more information on that, because when you have, it depends on your criminal history, because I assume you're talking about a warrant, like a criminal warrant. If you want more information on that, please shoot me an email, because that is a very specific question. is there a link to begin this application? If you are going to do this application by yourself, you can go to USCIS's website, get the forms, and go through with it. I do advise always using an attorney because the forms are not as simple as they look. And the evidence that goes into it, USCIS doesn't provide you with that list. They tell you the elements, but they do not tell you what evidence will help you get a successful or unsuccessful case. So you can go to USCIS and download that I-140 and fill it out and try your best luck. But I always push going with an immigration professional or an attorney. What is the cost and guarantee of securing a job? Hi, Victor. So with this visa, you do not need to secure a job. The point is with the EB-1 and EB-2, neither categories require you to have a job offer or an employer. This means that is not a question. You are only proving that you meet the elements that were presented today. USCIS does not care. Even if you had a job offer, it would not mean anything to them. It's nice. It's nice to have as additional evidence to show that somebody values your skill in your career. But if you cannot meet the other elements, USCIS does not care, and they will not grant you with that green card, and they will not approve your petition. My visitor visa was rejected twice. Can I still apply? Absolutely. Any denial that you've received does not affect any future petitions. There isn't a crossover period. They're not looking back. The only thing I do want to say will affect your immigration history as a whole is if you have violations, which means unlawful presence, unauthorized work. If you, depending on how far of that, how long you were in without status, there are just certain levels, and there are waivers, which is why I say if you do have some of these issues, you can contact me so I can see if there is a waiver available to you. You did not talk about the process from coming outside the United States and premium processing. I did talk about the process from outside the United States. It is the same. You start off with USCIS, then it goes to the National Visa Center. National Visa Center gives you a visa. You have to go through your interview, and then you're able to enter the United States, and they will mail you your green card. There's not much of a difference. The only difference is you now have to go to an embassy and continue that way. Premium processing is available in these cases. What happens in premium processing is that you pay, and now it's gone up to 16.8. I think it's $1,805. So you pay $1,805 and you can get an answer in 15 days. I do not push premium processing. And the reason that I don't is that it is unnecessary and can put you in a worse position depending on why you're needing to premium process. I only think premium processing is necessary if you are about to lose status and you need an answer fast. That is the only time I would push premium processing. I don't like to push clients or potential clients to spend money that they don't have to. With processing times only being between, I think is what it said, 6.5 to 8.5 months, I just would not do it. But if you really want to answer in 15 days, you can pay that $1,805 to premium process. And all that happens is you just file I-907 with your application, and USCIS will give you an answer in 15 calendar days. You're a manager at a US JP Morgan bank. Mahesh, I would love to give you an answer as far as what the growth rate and everything is for you as a bank manager, but I do not have the research in front of me. I do custom research for every potential client. So if you would like to know what the growth rate is in the possible success, I would suggest either signing up for a consultation or emailing me so that I can do that research and give you an answer as to what the growth rate is, what your education is, and what the possibility or the success rate would be. Could you provide the details for the evaluations you spoke of? Is it PARC or PERC? I will actually type it down here, PARC evaluations. There we go. I think it'll go in there. That is what it's called, PARC evaluations. And it's a great service. You can get it back fast, and their academic evaluations are valued. Sorry, I'm looking at the questions. EB5. I am well experienced with EB-5 functional personnel. Again, anything specific that's required, that when you're speaking of what exactly your job title is, you will need to email me personally so that I can do that research. Because again, one of the biggest parts of this application is that national importance. And I can't tell you off the top of my head what the levels of national importance are as far as your specific careers. Are there other centers aside from the two mentioned? Not for these categories. They can only go to one of those two centers, unfortunately. Can I travel out of the country if my petition is denied using my F1? Joyce, that would depend. If it was denied, that depends. Do you have underlying status? Do you have a travel permit? That would depend on so many other things. Victor, coming from Nigeria does not affect your ability. What you want to see for these categories is it's really about meeting the elements and showing that evidence. It's not about where you're coming from whatsoever. So, yeah. And if you guys have any more questions, I hope I was able to answer at least some of the questions that you guys put in the chat. If you have any specifics regarding what our costs are or what the national importance is related to your area of expertise, please feel free to email me. Thank you all so much for attending today. I look forward to hopefully speaking with some of you guys in the future, and I hope you guys have a wonderful day, evening, afternoon, wherever you're located. Thank you so much.